To choose the most appropriate legal form of legal protection for your business, the first thing that you should do is to clarify your business targets. The invention, as a part of patent law, should be mandatorily registered in the local official body, like Patent Office or Ministry of Economy. Patent for invention can help you, first, to be recognized as an author, second, to provide legal ground for your business, third, to receive the state grants and projects, fourth, to get the access to scientific communities, and fifth, to be nominated for any academic degrees. But invention is not good for the business products and market operations, because it is almost impossible to stop the activity of an unfair competitor using a patent for invention. Let's consider now the work of science that belongs to the copyright law. With the work of science, which should be registered in the Copyright Office, you can do the following things. First, block the unfair competition. Second, monopolize the market niche or segment. Third, provide real protection for your business. Fourth, create the monetization system with additional source of income, like additional profit from licensing or franchising agreements. Fifth, protect the creative concept of product or technology. Regarding the know-how, we should mention that this type of IP is from commercial law system, what means acceptance and approval of know-how inside the company based on internal regulations without any registration in public patent or copyright offices. You need know-how if you want, first, to attract the investors, second, to protect innovations inside the company, and third, to have verification for created works, fourth, to capitalize the cost, and fifth, to provide full control over your employees. The low efficiency and practically weak legal power of the inventions patent we can see on the many cases in the Chinese car market. Since 2004, almost all biggest international car makers opened a huge amount of legal cases against Chinese unfair competitors. But the patent holders didn't achieve any practical results in China. For example, very well-known Japan auto brand Honda failed after accusing Shuangguan Auto of copying the CR-V model. Porsche, with more than 20 registered patents for invention, could not make any legal action against Chinese company Zotti that simply cloned the Macan, one of the most famous car model of Porsche, and now this Chinese company Zotti, without any problems, is selling illegal copies of Porsche car in China. And there is only one successful significant case against unfair car makers in China. Range Rover won a lawsuit against Chinese Land Wine Company due to the violation of 5 copyrighted car details of Range Rover Evoque model, because they were registered as a copyright work of science, which provides protection for whole creative concept of car, design and technological elements. Let's now compare the registration period. To register invention, you need from 1 up to 2 years. Work of science could be registered within 20 or 30 days. And protection of know-how will take up to 25 days. As invention, usually people and companies are protecting something physically existing: mechanisms, machines, apparatus, technological devices, engineered constructions, and technical methods. Work of science is covering all types of invention items like devices, and additionally protect business models, startups, IT solutions, computer programs, mobile and web applications, projects, games, products, and services. In form of know-how, you can protect food or drink recipes, compositions, internal IT solutions, devices, non-disclosed practical knowledge, skills, and expertise. Regarding the regions and countries of protection, we should note that authorship of the invention will be worldwide recognized, but protection will be provided only in those countries where the applicant paid additional official fees. Work of science provides not only worldwide recognition of authors, but also the possibility to conduct all required law enforcement actions against violators in all member countries of Berne Convention on Copyright. With know-how, you can protect your right only in case of leakage of confidential information from the company, which is the rights holder of know-how. What is the period of legal protection? Patent for invention is valid from 5 up to 25 years and depends on annual renewal payments of patent holder. Work of science will be protected during the life of the author and 50 years after his death, and know-how will be valid only within the working period of the company. Forms of possible responsibility of violators are following. For invention, patent infringements, civil responsibility. For work of science and know-how, civil and criminal. Now let's study which particularities of legal protection are existing. Using patent for invention, right holder can ban only identical plagiarism. It means that any unfair competitor can get a description of your registered invention from the patent office absolutely free of charge, and after minor and insignificant changes of description, he can apply to the patent office and receive another official patent for the invention, which will be very similar to your patent. And you cannot stop his activity because your patent and patent of unfair competitors are not identical. Second, in case of official refusal for invention registration issued by the patent office refusal, the applied work will lose the novelty. Main legal criteria of protectability, an applicant cannot reapply for registration. The most important advantage of patent for invention is a right of patent holder to receive free support from the local anti-monopoly bodies, which are responsible for unfair competition regulation. But if violator will not agree with the decision of anti-monopoly body, the case will be filed to the court. If your product is protected as a work of science, you can block the activity of unfair competitor based on general similarity of registered creative concept. It means that not only identical but also similar works will be banned. To protect your IP rights for work of science, you should be directly filed to the court without participation of local anti-monopoly body. Real protection of rights for know-how is very difficult due to the lack of established legal practice of comparative analysis of the plagiarism similarity level for know-how items. Protection for know-how holders could be provided only by the court.